did arrive in Ramljane. And yesterday I cited from Janeč's testimony that he, as the responsible commander, looked into Ramljane and decided that there was no need to conduct any kind of disciplinary measures. What I did not include, and what I will include out of Janeč's testimony at 6193, beginning at line 23 to 6194. And he's talking about Ramljane. And Janec says, later on, before departure, or before we went other own separate ways, the general, referring to General Markača, trusted me with verifying all this information to interview the commander of Lučko and other commanders in order to verify whether the reports were true. After these interviews, I established that this is exactly what happened. Now, it's the Office of the Prosecutor's position that the inner control now of the Special Police was somehow the source for Markača to know at 5 o'clock on August 25th that out of the 6 special police units of 580 members, it was Lučko that was in Grubari. And because of that, he shouldn't have sent Lučko into Ramljane. Well, I believe I adequately explained yesterday how that was not possible under the evidence that's been admitted in this case. There's no evidence where General Markača was on August 25th. Was he in Gračac? Was he elsewhere? Now, there's no reason for him to call Sačić to go down there if he already knows that it's the Lučko unit. If he has all the information by 5 o'clock on August 25th, what reason is there for him to ask Sačić to go down and find out what happened, as Sačić said? And we still haven't demonstrated the prosecution has still not demonstrated beyond reasonable doubt that Markača knew Lučko was in Grubari before the Ramljane Freedom Train operation. Let's talk about Gračac for a moment. Mr. Russo yesterday said, or 2 days ago said, that the Janec reference he provided discussed Gračac and targets in Gračac. Well, that's not what it discussed. I showed you the transcript that he referred to. Now they bring us to another transcript and says, well, yes, Janec does refer to Gračac and targeting and targets. Well, that reference is page 635556. And when we go to that reference, at line 19, Mr. Janec is asked, to the best of your recollection of the days spent in Gračac, can you tell us what the situation in town? What was the situation in town? Was there any damage on the buildings? Just in a couple of sentences. Answer. Since after I reached the road near Prezid, I entered Gračac, and I can confirm that the town was intact. There was no damage caused by artillery. There was no immediate fighting over this particular town. Therefore, that there was no reason, and I know that near town there were some military depots that were legitimate targets, but the town itself wasn't. And there was no fighting inside it, and there were no artillery strikes targeting the town. Mr. Janec doesn't talk about military targets in the town. He says the town itself wasn't targeted. There's a big difference. The prosecution is very critical of various orders saying put certain towns under fire. Well, here's Mr. Janec saying there were no artillery strikes targeting the town. Of course, the prosecution has conveniently ignored the citations to Turkal yesterday that I made and the other witnesses that I identified, and I will not go over them. However, I will refer to Mr. Vornik, his testimony at 26-257, asking him Did you see any craters from shelling in various parts all over the town, as Mr. Steenbergen says in his statement? Answer, no. I saw several craters at the crossroads just outside the town. As for the town itself, I don't recall there being any. The court will recall Mr. Vornik was a witness to the defense from the special police. Mr. Vites, similarly a defense witness, from 25-988 through 25-989, talks about damage. But he says, in Gračac, as far as I remember, they had been destroyed a long time previously. There had been vegetation growing out of the ruins. I don't remember any other damage. Witness Zvrk also describes 25-375 through 25-376. Witness Turkile, in a reference that I didn't make yesterday, states at 13-772, I was surprised at the fact that there was no civilian population there, and he's referring to Gračac. It was already said that the targets engaged in Gračac were engaged with an exceptionally small number of projectiles in view of the number of targets in Gračac. To draw a comparison, I was present in the area of the town of Karlovac, where hundreds or even thousands of rounds landed on Karlovac, and the population never abandoned it. It was always there. So the movements of the population can never be correlated with the activities of shelling, or at least I could not when it came to the shelling of towns that came from our side. Witness Herman, also a defense witness, transcript reference 26-435 through 26-436, describes apart from some craters could be seen on the tarmac. He talked about the main road in Gračac. It was in fair condition. So as far as the citation references regarding Gračac, they're either non-existent or completely misinterpreted. The last thing I wanted to state, Your Honor, in conjunction with my colleague, Mr. Mikulicic, is while I thanked many people yesterday, I didn't thank the three of you judges for listening to us, for your patience, for your obvious engagement in the case, and for at times knowing certain portions of the case better than the defense lawyers or the prosecution. I join my colleague, Mr. Mikulicic, in seeking our client's acquittal because the prosecution has not proven its case beyond a reasonable doubt. Thank you very much, Your Honors.
Thank you, Mr. Kuzmanovic.
Your Honor, before you concluded, one small housekeeping matter. I just wanted to indicate, in keeping with what we've done thus far, should the court wish the prosecution to provide the slides shown today, we're prepared to do so, but leave it to the court.
Let's resolve this in the following manner. If any of the parties would like to receive it, they'll address you, Mr. Tige, and once you send a hard copy or an electronic copy to any of the defense teams, the chamber would like to receive a similar copy. We're not yet at the end. I just want to have a few matters clear for myself. Mr. Akkerman, you more or less assumed that silence would be understood as an expression of a position. But did I miss something? And it's very possible that you did not explicitly respond on the Hatziazanovic argument raised by Mr. Tige, that where the character of the conflict may have been of some importance in the Hatziazanovic case, that it does not anymore. Is that a matter which you would like to further address? You'll understand that I was hesitant to consider it to be having acceded to the position of the prosecution. Yes.
Yes, Mr. President. First of all, the Haji Hasanovic case did not deal with the scope of application of internal versus international armed conflict matter, which, as you appreciate, was resolved in a Tadic jurisdiction decision quite some time earlier. It dealt with the allegation that Article 7.3 does not apply in internal armed conflict. But the point from that decision is that the appeals chamber clearly stipulates that in order to rely on international armed conflict, it must be expressly charged in the indictment. And to the extent that the prosecution is relying on an international armed conflict to vest this court with jurisdiction, it must have expressly stipulated that in the indictment. That is the issue. And I would add also that the Dragomir Milosevic case in 2005, I believe, had a similar finding as Haji Hasanovic. Unfortunately, I haven't had time to find that precedent for you. So we do not concede the point.
Yes, that's clear. I took it from Mr. Tiger's position that he doesn't rely on anything you say he should then present or put to the chamber. But that's at least clarified. I have one also for you, as a small question. You point at the Ethiopian Eritrean Claims Commission. Would you agree with me that the way in which you presented that was more or less a one-liner? You see how broad the powers are of a Belgian state to expel some mass expulsion of enemy aliens. You relied on Lauterpacht, the 1996 edition. Would you agree with me that that matter is far more complex, as explained by the study of the ILC in 2006, and that to have to fully appreciate the matters that, apart from your one-liner pointing at the broad powers that for it?
Do we switch off all unnecessary microphones?
Yes, my microphone is on necessarily at this moment. Would you agree with me for a chamber to have a broader and a more balanced view on the matter, that it should consider these elements as well? And would you consider that to be appropriate in dealing with the matter, which, by the way, was only a subsidiary argument for you, because you said Croatia would have had the powers, although that was not the reason why the Serbs left the territory.
Yes, Mr. President, we did not invoke that authority to justify a non-existent mass expulsion, as I tried to explain. The point is that it is permissible for a state to deny the mass return of enemy aliens in armed conflict. And that is the issue here, that the prosecution is relying on a policy of no immediate mass return in order to infer criminal intention. And we believe that is inappropriate. The International Law Commission study that you referred to, of course, is relevant. And there was also a study prepared by the Secretariat prior to that, which was submitted to the International Law Commission. I referred briefly in my presentation to the fact that in cases of state succession, which is what we have before us, the customary rule, arguably, is that habitual residents of the new successor state must have the right to citizenship of that state, at least where they become stateless. Now, in this